Hey everybody, good afternoon or good morning, wherever you may be today. I just want to jump in here real quick to make sure the audio is working fine. If you could please just chime in on the questions part of your control panel. I see some people already doing it, so thank you for that. And we'll just give it another minute or so and let the rest of your colleagues join, and then we'll get started. Okay, hello everybody. We'll go ahead and get started here. My name is Matt, and I want to first say thank you so much for signing up for our session today. We're really grateful to have you and have you spend this hour of your day with us. So thanks so much for that. I want to say a couple things before we get started that everyone joining today will receive a copy of the slides as well as a recording of the presentation and your CEU certificate, which is good for 1.2 CEUs. So we are happy to partner with the CCB and be able to deliver those to you guys later this afternoon. So be on the lookout for all of that. So today's session, practitioner license and sanction monitoring, how to get it right. And we have an awesome guest speaker here today. If you've been to our webinars before, you'll recognize Donna Thiel here on the right. She is our Director of Compliance here at Provider Trust. She has 30 plus years in the long-term care industry, and she helps compliance officers and HR professionals handle the stress of their daily roles. And we're very happy to have Alex Fisher here today. She's a senior associate with Frost Brown and Todd here in Nashville representing healthcare professionals. She's recently been appointed by the Nashville Mayor, David Briley, to the Hospital Authority Board for the Nashville General Hospital. And she's also a faculty member at the Vanderbilt Center for Professional Health, where she teaches a continuing medical education course as part of the center's maintaining proper boundaries and prescribing controlled drugs curriculum. So she's very qualified to be here today, and we've got some great information to share with you all. So let's get started. A little bit about us. We are here in Nashville, Tennessee. We partner with a lot of organizations here and across the country, and we just help them with their compliance and HR ongoing monitoring needs of license, sanctions, and exclusions. So we love it here in Nashville, Tennessee. It's a very exciting place, and it's busy pretty much all the time. So we hope to see you actually in 2020. HCCA Compliance Institute is here in Nashville. So put that on your calendar, and we hope to run into you then. So we love to offer these resources to you guys. One of our company values is to help others grow and succeed, and this is a way we think we can do that. And got some great feedback on our webinars, so we're just happy that you're able to join us, learn with us, and grow from this information. These are ongoing monthly, and you can see what we have coming up here. We'll have a recap of the CMS preclusion list for the first 5 months on May 15th, and then we'll, back by popular demand, on May 29th, we will cover how to conduct an internal investigation. And then we're still in the works for the middle of June, so please give us your feedback at the end of this presentation, and we'll certainly take that into consideration as we come up with our topics for the rest of the year. So with that, today's agenda, we'll start out with the practitioner landscape, move on to organizational responsibilities, talk a little bit about the reporting, then go into National Practitioner Database update, and finally, we'll give you some key takeaways to take to your colleagues and enact at your organization. So we will kick it off with Practitioner Landscape.
Well, thanks, Matt. This is Donna Thiel, and as Matt said, thank you all for joining us again this month. We're super excited to have Alex join us as a guest speaker with us, and I think she was on one of our webinars with us last year. She's just a great resource. So excited to have her today. So let's get started. We're going to start off talking about the practitioner landscape and kind of what it feels like, what it takes to be a practitioner, what differences are between licenses and certificates, what all the boards are, that sort of thing, as we get started. So let's move on to kind of how it works. Certainly in an overly simplified fashion, but it all begins, right, with completing our necessary education. That looks and feels very different, but depending upon what sort of a healthcare practitioner you are, it can start with a certified nursing assistant, obviously to an LPN, to an RN, to a physician with all sorts of specialties and everything in between. So certainly finishing your necessary education. There's all sorts of testing that comes with those different certifications and licenses. And then we go through an application process depending on the certification or the licensure that we're looking forward to. We have to apply to the various boards, and they have to look at all the credentials and all the experiences that we've acquired through that period of time to determine whether or not we qualify for the license or certification that we're requesting. And then hopefully everything goes well and that board says, yep, you qualify, and they give us the license or certificate that we're hoping for. And then the ever most important part is keeping that license and certification in good standing. And I think all of us in the healthcare space can attest to that. That becomes one of the most difficult things for those of us in the oversight roles, responsibilities of monitoring, of how we're going to monitor and make sure all of our healthcare practitioners are keeping those licenses and certifications in good standings. On the next slide, we have kind of an oversimplified statement, but that there are over 400 licensing boards across the United States. At Provider Trust, we spend a lot of time monitoring licensing boards and sanction authorities, and we say about over 2,500 different monitoring locations that we look at on an ongoing basis to help our healthcare providers make sure that their staff are properly licensed or certified. So it's a very, very difficult process. So Alex is going to walk us through and help us just kind of go again back to those basics of what's the difference between a license and a certificate, and then talk about what happens when practitioners perhaps make a mistake. So Alex, I'll turn it over to you.
Awesome. Thank you, Donna. So just to start, let's talk about the difference between a license and a certificate. So typically, a license permits a broad range of conduct for a provider. And when I'm using the word provider today, I'm just talking about a healthcare provider. So as Donna mentioned a few minutes ago, that could be anything from an LPN to an RN to a nurse practitioner to a physician assistant to a medical doctor. So typically, a license permits a broad range of conduct for a provider to engage in the licensed profession. A certificate typically bestows the holder of the certificate with a more narrow set of privileges. So an example is here in Tennessee, the right to prescribe drugs as a nurse practitioner requires a certificate of fitness. And now sometimes these words are used in non-distinguishable ways, right? So a nurse practitioner may have a advanced practice nurse certificate and a registered nurse license to practice as a nurse practitioner. So there's a difference, license usually broader, certificate more narrow, but sometimes the words are used interchangeably. And what does a state regulatory board do? So obviously they regulate individuals in a healthcare profession. They set forth specific qualifications to be licensed in that profession in the state. They set forth the educational curriculums and standards for any educational programs for that profession in the state, right? So if we're talking about a board of nursing, they set forth the standards for all nursing schools that are in that state. And then this is the big one. Their mission is to safeguard the health, safety, and welfare of the public by ensuring that those who are licensed to practice are qualified. So their job is to protect the public. That's really why these boards have been created, to make sure that no one's able to practice in a certain field who's not qualified to do so or isn't competent to do so. They interpret the statutes and rules to determine appropriate standards of practice, And then finally, they can discipline licensees who are found guilty of violations. So that's just kind of a broad overview of what a state regulatory board does. So what if the practitioner makes a mistake? Right? And what if the practitioner doesn't even just make a mistake, but someone thinks they made a mistake? Right? So a board investigation may look something like this. And I'm really going to take this at a broad view. Those of you on the phone may be very intimately familiar with what this process looks like in your particular state with a certain particular board. I've worked in about 12 different states with a number of different boards in those states. So this is just kind of the general way that this process works. And if you have any specific questions, Matt will give you our contact information at the end, and I'm happy to talk to you about it. So first, a complaint is filed with a state licensing board. In most states, this has to be in writing. So what that means is you can't just click through a website, right, in the heat of anger and submit a form. Usually it's something that has to be printed out and mailed in. It just adds an extra layer to making sure that complaints are done thoughtfully. And depending on the state, a complaint could be filed anonymously. So in many states, you may know the name of the person who's filed a complaint against a provider that works at your company, or you may not. So for example, Tennessee complaints can be filed anonymously. That just varies from state to state. Once a complaint is filed with a state licensing board, they'll review it to see if evidence exists of a possible violation, right? So this just means that if the complaint is, my doctor is a real jerk, even if the doctor is a jerk, that probably doesn't violate the laws or regulations governing his or her practice. But if the complaint says my doctor is writing prescriptions to people who he or she doesn't have a patient-provider relationship with, or who are family members, well, if that's true, that could be a violation of the laws and regulations in that state. So they're going to proceed forward with an investigation. An investigator will be assigned to make an inquiry. And there are really three ways that a provider is going to be put on notice that they're under investigation. They may receive a letter in the mail that says notice of complaint. They may get a phone call from an investigator, or an investigator may show up at their place of work. So one of those three things: letter, phone call, or in-person visit. Now, at this point, it's important for providers to know, and for those in compliance to know, that a provider has a right to have counsel if they choose to do so. So if an investigator shows up and says, we'd like to pull 15 files, even if they have authority to do so under the statutes and laws in the state, that's great. What the provider can say is, let me get in touch with counsel for this organization. Or I'd like to hire my own counsel. He or she will be in touch with you. We're going to comply. We're going to make sure that goes through counsel. And that really ensures that a provider doesn't feel pressured to sit down and have a 6-hour interview, which is something that's happened to individuals before, and that this process is able to be appropriately addressed, and that everyone receives appropriate notice. And then finally, summary suspension can be imposed if the State Department of Health determines that the public is deemed to be at risk. So if summary suspension is imposed, that means that that provider cannot practice on their license while the investigation is ongoing until either the complaint is dismissed, they agree to discipline, or a hearing is scheduled. So for everyone else where summary suspension has not been imposed, they still have a valid and active license throughout the whole investigative process. And this is a good point to mention, that for those of you that represent various entities, that it's very helpful to put in your hospital bylaws or your employment contracts or your employment handbook some requirement that if providers are under investigation, they have to notify you, the employer, within X number of days. That doesn't mean that you're going to terminate them. It doesn't mean that anything's going to happen. It just means that you are on notice, because there might not be a way for you to receive this notice other than directly from the provider. So how are complaints resolved, right? So an investigator reaches out, they either call, send a letter, show up. Hopefully counsel gets involved and helps guide that process to make sure the investigator receives the information he or she needs to conclude their investigation. Complaints can be dismissed. Lack of evidence. A letter of concern or a letter of warning can be sent to a provider. This is just a letter generated expressing concern or warning regarding an action. This is not considered formal discipline. It's not reported to the National Practitioner Databank. In most states, this is not something you can access through a public records request, and it would not be available through the state agency website, right? Consent decree is an agreement used for concerns such as an expired license or incomplete continuing education requirements. that is not considered discipline and not reported to the National Practitioner Databank. The next two are considered discipline and are reportable to the National Practitioner Databank. A proposed consent order would be the state agency, the Department of Health, offers proposed licensure discipline. The provider can agree to certain terms and or conditions, and it's presented to the board for approval. This is basically just settling the case before you go to trial, right? If a provider agrees, look, I made a mistake, I'm going to agree to certain action, that's what a consent order would do. And then finally, a provider could go to a hearing, which I say it's a trial-like procedure, but it's really their trial. It's their opportunity to present their case. The board that they're before, whether that's the Board of Medical Examiners, the Board of Nursing, is essentially the jury. So they'll hear proof from both sides, from the Department of Health and from the provider, and they'll decide if discipline should be imposed, and if so, what that discipline should look like. And that leads us into our last slide here, which is what sort of discipline could be imposed, right? Either by agreement, by a consent order or an agreement, or by the final action of a board after a hearing. And this is essentially from lowest to highest form of discipline here. So a reprimand is published disciplinary action that expresses concern about a provider's actions. This is reported to the National Practitioner Databank. Unless there are other terms or conditions along with the reprimand, it is not considered an encumbrance. The next is probation. Now, most state boards don't have a probation office, so this is not like criminal probation where you're assigned a probation officer and you have to do X, Y, Z. It may truly just be the word probation on the website alongside a provider's license for a certain number of years. Now, typically what we find is probation paired with restrictions, right? So you have probation on your license, and then there are restrictions for the length of the probation, such as peer supervision, restricting what you can prescribe, limiting the hours worked, or limiting the gender of patients a provider can work with. So provider agrees to probation or restrictions or some combination of the two. That's going to be considered an encumbrance on that provider's license. And the reason why that word encumbrance matters is that for those of you who are employers or supervising providers, you may already know if a provider has an encumbered license, they may no longer be able to have privileges at a hospital, for example, or may not be able to be employed at your place of business, right, if that's part of their employment agreement. It may also limit what insurance providers will accept them if they have a restricted license or if they have a license that's on probation. So there can be quite a few ripple effect repercussions of a provider who's on probation or restrictions to be thoughtful about if you have a provider in your organization who does have probation or restrictions. Suspension is the loss of the right to practice for a period of time. The board will usually specify conditions which must be met for reinstatement. And then finally, the last two are frankly interchangeable. Surrender just sounds a little nicer, right? It sounds like you're agreeing to it. Or revocation means you don't have a license anymore. It's usually not permanent unless it says revocation without leave to reapply or surrender without leave to reapply. Typically in most states, you can reapply after 1 to 2 years. And if you are agreeing to revocation or surrender, most providers will usually negotiate what they need to do before they can reapply for their license. Donna, I'll turn it over to you. We're going to go through organizational responsibilities next.
Excellent. Thanks, Alex. So now we kind of have a good understanding of what it feels like to be a practitioner, the things that can happen if there's a mistake or some bad activity takes place, what the different board sanctions might be. And for those of us on the organizational side, now we have to think about, all right, so how do we manage to that? How do we make sure we have the right people taking care of our patients? So let's just start with kind of 5 key steps, if you will, to practitioner monitoring. So it all starts with our pre-hire process. So really understanding what are the state or federal pre-hire requirements, what sort of criminal background checks, abuse checks, those sorts of things that are state or federally defined, making sure that we understand all of those things, right? Then we have to decide what are the things that we want to do as an organization? What kind of requirements are we going to mandate? So really just identifying all of those pre-hire requirements is step 1. Then we have to say, what kind of process are we going to put in place so that we can really make sure that all of those requirements are accounted for? So it's easy to say, excuse me, easy to say, we need to make sure criminal background checks are completed. We need to make sure the license is verified, that there aren't any sanctions against or restrictions on that license, or that the OIG check and all of our state Medicaid agencies are checked. But how do we make sure that we really can confirm that those things are happening? What processes or double checks, if you will, are we going to do that? So once we have kind of that pre-hire process and maybe an auditing or monitoring process in place to really double check to make sure that those things are taking place, now we have to look at how do we make sure that we can maintain or make sure that our practitioners are maintaining credentials the way that we want them to. So thinking about, again, how are we going to monitor for exclusions? Alex was talking about on the license status, we might not know, we might not have the ability to know that there's an investigation going on against one of our employees. So then what kind of processes do you have in place? Like Alex said, is it in the contract? Is it in your employee handbook? Is it in your bylaws? Where is it that we tell our employees that there's an expectation that they notify us if there's any sort of investigation going on surrounding their ability to perform their job function within the organization? How are we going to monitor, or how are we going to communicate perhaps if there is a sanction on someone's license? Now Alex talked about restrictions on a license. So what if you have a nurse manager who has been passing meds? That's, she's on the PM shift, and so she's the RN who's passing meds on a particular unit, and all of a sudden she now has a restriction on her license that she can't manage narcotics, she can't handle narcotics. What are you going to do within your organization to make sure you're aware of that and to monitor on an ongoing basis that there's no perhaps change in the director of nursing such that you no longer have someone within the facility, the hospital, whatever it might be, that knows about that restriction on the license? So it's really important that you have processes in place for ongoing monitoring and communication, that you're aware of any restrictions or sanctions on someone's license or any significant change, such as an exclusion or a new sanction. So then what's your internal process for reporting any allegations? So what if Sally, Nurse Sally was out in the community and got arrested for drug possession, or something happened, and one of the other staff members of your particular nursing home, hospital, whatever it might be, saw that, heard about it, didn't know what was going on? Do you have a process where there's a hotline, or there's some way that people are communicating that know that they should report information that they're hearing, if you will? Understanding what your controls are going to be or ways to report that information. And then last is monitoring and reporting as needed. And Alex is going to spend a good amount of time at the end of this session today really helping us understand those reporting responsibilities, because I think we all agree that that can be a really stressful time. So let's go in now to the pre-hire process. I think I talked a lot on that last slide, so I might have covered most of these. But really understanding what those federal and state pre-hire processes are, identifying each license or certificate requirement for each position. So we talked about a lot about really helping make sure that we know for each different role within the organization that you know what credentials or requirements you want that particular practitioner to have. A nurse is not always a nurse, right? In different departments that they provide care to, they may have different certificates on top of just as an RN license that they also have to have. So really making sure that you know what those licenses and certificates are for each position so that you can make sure that they have them. Defining who can handle or who is going to handle each part of that pre-hire and check and verification. Do we understand where that role and responsibility falls within the organization? Making sure that you have the proper policies and procedures, right, surrounding pre-hire processes and first day of work rules. In my former life, we had a policy that no one could start, right? All of the criminal background check, the abuse registry, the license verification, all of that process had to be done before they could work on that first day, making sure that you don't have slippage in your process that says, oh gosh, if they just come to orientation, that'll be okay. We can finish up any of the pre-hire process, early in their first week or so. That's not going to be a problem. I think in the compliance world, we probably would argue that that might be a little bit of a problem. And then again, monitoring for compliance, making sure that we understand or that we are confident, I should say, that all of the pre-hire checks that we put in place are actually being done, and we are confident that the right people are coming on board into our organization. So let's talk about monitoring of a mobile workforce. In today's world, in healthcare and really beyond healthcare, but people don't stay in they don't stay at one organization as long as they used to. They certainly move around within the organization. So the mobile workforce, we know people are moving state to state, company to company all the time. So it makes it even more difficult, I think, for us to stay on track or on top of all that movement and the changing. So this is a real world example of a scenario related to a nurse. So the timeline starts in June of 2016, and there's an allegation of theft of money from a patient. So this is just an allegation made by a healthcare provider. They make that allegation, they report that information to the appropriate licensing board. It takes the board 12 months to complete that investigation. And if you remember earlier, Alex was talking to us about all the different components and the ways that a licensing board would potentially investigate these sorts of allegations. So finally, 1 year later, the licensing board makes a decision that they are going to take an administrative action against the person. That particular person is given 30 days to defend themselves if they, however they would like to respond to those allegations. The person, for whatever reason, chooses not to defend themselves. And so at that point, the board revokes the license. So now, 13 months later, there's a license revocation. So as many of you know, state actions can grow into exclusions. And we're going to talk about that in another minute or two in another slide. But in this situation, the information was finally reported and shared and reviewed by the OIG 7 months later. And at that point, the OIG made the decision that based on the license revocation, they were, in addition to the license being revoked, they were going to exclude this person under the authority that they have. And in January, they excluded the person. Now, we know Sam Dakov, Sam pretty much does whatever the OIG does. So that very same time, they are also excluded from the SAM. So now, fast forward 5 months later, and for all we know, this may have happened a year ago or 18 months ago. Who knows when this person moved, but we know during this period of time, from the time that they lost their license to May of 2018, they moved states, they changed their name, and they received a new license. Now, we know that these board actions take so long. We know people are transient. We know in some states it's easier to get a license than it is in other states. So perhaps I'm in Wisconsin and I have a license investigation going on. So I'm going to move to Minnesota. Why my license is investigated? There's nothing that I'm reporting. It's just an investigation. So I get a new Minnesota license. And for whatever reason, perhaps I got married, divorced, who knows, but I changed my name as well. So now I'm living in Minnesota. I have a brand new name. I have a valid license, and everything seems to be hunky-dory. So I get a new job with this new organization. They check my license for Minnesota. It appears to be in good standing, and I have a different name. And if they're only going to the OIG site and typing in my name, guess what? I don't come up as a match. But unfortunately, I really have been excluded under a former name. So it's so important as you're monitoring your mobile workforce that you're asking the questions about Have you practiced in another state? Have you had any other names? And making sure that your practice takes into account all of that change that could have come from a previous move or name change. So let's talk just quickly about exclusions a little bit. So exclusions come from all different kinds of places. So when we're thinking about monitoring our people and we're talking about licenses, I think it's important to really understand how many different places exclusions can come from as we're trying to monitor our entire workforce. So many of the exclusions start at the state level. So the Medicaid Fraud Control Unit conducts some sort of an investigation, and they make a determination or a decision that they're going to exclude someone at the local level. They have an obligation to report that same information to the OIG so that the OIG can make the decision as to whether or not whether it's mandatory that they also have to exclude that person, or if it falls under the permissive category and the OIG has the decision as to whether or not to exclude them. One little side note here will tell you that based on our data that we have at Provider Trust, the timeline that it takes for the exclusion to move from the state level to the OIG level on average is 173 days, which when you think about that, that's almost 6 months. So if you're only monitoring the OIG and not monitoring the states, there's a 6-month period where you may be missing a fair amount of information. We also just mentioned in the previous slide in that timeline that after a license revocation, the person was also excluded by the OIG. On our next slide, we're going to highlight that a little bit, but we can tell you that 43% of the OIG exclusions relate to license revocation. So a huge portion of exclusions start at the licensure level. We also know that the OIG has permissive authority to exclude someone for misdemeanor actions in the healthcare space, and basically the same misdemeanor actions or healthcare issues that are at a felony level will cause the OIG to have a mandatory exclusion. So they have permissive authority if it's a misdemeanor level action, but if it's a felony action, then the OIG has to exclude you. And the last one we always want to highlight is a student loan, and this one, in my experience, has caused the most aha moments and oh my goodness, I had no idea sort of conversations. If you're in a healthcare practitioner and you have defaulted on a student loan, the OIG has the ability to exclude you. Now, the difference in a student loan exclusion is that you actually can resolve that, and the exclusion, generally, the OIG exclusions are typically what? 5 years, sometimes they're 10 or 50 or indefinite. A student loan, you actually can clear the student loan, and the exclusion, you'll be removed from the OIG exclusion list. So that's one that you can actually take care of. But I will tell you, in my experience, every time we tell someone that they have an exclusion by a student loan, generally the response has been, oh my gosh, I had no idea. Let's look just a tish deeper at the specific licensure exclusions, just because I thought it was kind of an interesting statistic. So there's about 30,000 exclusions specifically for the license revocation. And if you look at the information on the right side, you can see that 22,000, the bulk of all of these come or encompass the nurses or nursing assistants. And if you think about the practitioners in most of our organization and our healthcare organizations, that's certainly the largest population of licensed or certified professionals in our health setting. So I think it's important to think about how to monitor and really think about a good monitoring practice. It really does start with monitoring licenses, because we know that a license revocation could ultimately result in an OIG exclusion. So as we're looking at our practitioners and trying to make sure that we don't have to worry about OIG exclusions, if we just start monitoring the licenses, it'll be hopefully a precursor and prevent us from having that scenario 6 months or 18 months down the road. So let's just finish off kind of this discussion with what do we do during employment. We talked about pre-employment. We kind of talked about that the different scenarios with the timeline and exclusions. And so while we're employing our practitioners and really our entire healthcare population, it's making sure that we have policies that first, require the employees to notify us. Alex mentioned that as well. Is it an employment contract? Is it your bylaws? Is it in your employee handbook? It's part of your orientation. Where is that process that we can communicate to people that there's an expectation put upon them to notify management of any changes in their licensure status or an investigation? And then how are we going to verify employees continue to meet all of our requirements? So what process are you going to have in place to make sure that there isn't a change to the license status? Now, we talk to people all the time about the sequencing of how are we monitoring that? Are you only going to the primary source to verify the license right at the time of renewal? Are you doing it once a month? Are you doing it every year? Really, what does that cadence look like for you in your organization? And obviously, from our perspective, the more frequently that you monitor the license, the quicker you're going to identify any concerns relative to a change in status of that license. And then, of course, tracking the license or certification renewal. My experience has been many times, somebody will say, oh my gosh, I just forgot to renew my license. Well, just forgetting to renew your license is a significant financial financial implication to a healthcare organization, not to mention the potential risk of quality of care issues to our patients. So really making sure that we're staying on top of all of our staff renewing their credentials appropriately. And then monitoring the licensing boards. What does that look like, and is that reasonable for your organization to do? But again, trying to stay on top of any licensure actions as quickly as you can when they're happening. All right, so let's go into the, sorry, Matt, I'm sorry. We're going to go to another section, but Matt's going to start us off with a poll question, I think.
Yes. So right before Alex gets into what if you have to make a report, we'd like to know a little bit about you guys. We're interested in if you've actually had to make a report or not to the regulatory board. So this is our only poll today, so just interested in who we have on the call today and any experience you may have in reporting. So we'll leave that open for about 10 seconds.
Thanks, Matt. All right, are we good?
We're good. Here we go.
All right. Well, look at that. An awful lot of folks have not had to report something to the board. So we are happy for each of you if that's the case. So as we get into this next section, Alex and I want to talk a little bit about what goes into making this decision about whether you're reporting. So I'm going to set it up just a tish for Alex, and then she's going to take it from here. But in my experience, making the decision as to whether or not to report is a very big decision. And I have had many times where I'm sitting in my office and, the general counsel's in the office and the chief nursing officer, myself, and we're on a conference call with leadership at a local facility trying to decide, first deciphering all the facts, but really trying to decide where do we land? There's considerations relative to law enforcement, whether they have to be notified. You have just ethical decisions on the impact to this practitioner of the licensing, and it becomes a much more difficult process than just a black or white decision. So as we walk through this next section, Alex is really going to walk us through. I don't want to say it's the black and white side of it, but maybe it's a little bit more definitive. But I would say when you're in this situation, trying to decide what board, if any board, what local law enforcement, whether it's the National Practitioner Databank, whether you're reporting it to the DEA if it's a drug-related issue, it's not as simple as it sounds, and you really do need to be having those conversations at a much larger level than just yourself as the chief compliance officer, seeking outside counsel, seeking your general counsel making sure that you're making the right decision is a difficult one, and one that I think takes a good amount of time and discussion to make sure that you've considered all the factors before you make that final decision. So with that, Alex, I will turn it over to you to help us walk through that difficult decision-making process.
Thank you, Donna. I appreciate that. And just to continue kind of teeing up this next section, we're really going to talk about the National Practitioner Databank, which requires mandatory reporting, and the couple of categories we're going to go through over the next couple minutes here before we finish up. These other reporting considerations that Donna's already talked about, state licensing boards, local law enforcement, the DEA, or other state and federal regulatory agencies. In general, we're talking about permissive reporting to all these other entities. So mandatory versus permissive reporting, right? So as an organization, you may decide and be correct in saying it's best practice if we think a provider has done X, Y, Z to report them to their state licensing board in the state where they're working. But most of the time, those sort of things, state licensing board, local law enforcement, DEA, are permissive reporting. There's usually not a legal or regulatory obligation on you to do so, versus the National Practitioner Databank, which you'll hear in just a second is a creature of Congress, does require reporting under certain categories, and there are some consequences for failure to report. So we'll go ahead and get into that now. So reporting to the National Practitioner Databank, just as an overview, the National Practitioner Databank, or the NPDB, as I may refer to it over the next few minutes, is a confidential information clearinghouse created by Congress with three real goals: to improve healthcare quality, protect the public, and reduce healthcare fraud and abuse in the United States. So it's really a national flagging system that permits those who can query it to perform a comprehensive review of the credentials of healthcare practitioners, entities, providers, and suppliers. And what it does is it collects information in medical malpractice payments and certain adverse actions, which we'll get into in just a few moments, and then it discloses that information to eligible entities. The National Practitioner Databank is not Google. It's not accessible to the public. It's not accessible to me. So if I'm advising a client who is concerned about a report to the National Practitioner Databank, they have to run a self-query report, and then they have to share that with me so that I can access it. Really, the goal of the National Practitioner Databank is to make sure that if someone's a bad actor, if they've done something, they've harmed a patient, they've gone outside their scope of practice, they've behaved unprofessionally, that they can't just move from state to state and continue to harm patients. So who are the entities with reporting obligations? As you can see here, there are quite a few, and I'll just run through them. Medical malpractice payers, hospitals and other healthcare entities, professional societies, right? So if a provider is board certified, such as the American Board of Family Medicine, that professional society may have a reporting obligation based on an action that's taken. Health plans, peer review organizations, private accreditation organizations, federal and state government agencies and law enforcement, state agencies administering or supervising a state healthcare program, or state licensing board and certification authorities. So you can see it's pretty exhaustive, and it covers this group of entities that are both in the private sector and in the public sector. And there's kind of a distinction in terms of the consequences of failure to report if you're in the private sector or the public sector as well. And we'll get into that in a few moments. So there are three types of National Practitioner Databank reports, three buckets that a report that's submitted could fall into. The first is a medical malpractice payment report for reporting medical malpractice payments. Pretty self-explanatory. The second is judgment or conviction report for reporting healthcare-related criminal convictions and civil judgments in federal or state court. And then the third, which is really the catch-all category, is the adverse action report. So all other actions that are adverse, that are required to be submitted, fall under this report category. So starting with the first, medical malpractice payment report. There are really three important things to know. And again, we're really doing the 1,000-foot view here today. There are a lot of nuances to what reports are required to be submitted to the National Practitioner Databank. So if you have specific questions, please don't hesitate to reach out to me after this webinar. I'm happy to engage in a discussion with you or point you to the right part of the National Practitioner Guidebook for guidance if you're an entity that has an obligation to report. The three important things to know about medical malpractice payments are there has to be a written claim or judgment, so in writing. Number two, it's demanding money. And number three, this written demand for money is based on a practitioner's provision of or failure to provide healthcare services, right? Three elements: in writing, asking for money based on failure to provide healthcare services. There are some nuances to it, but that's the basic landscape. The second type of report that's required to be submitted to the National Practitioner Databank is a judgment or conviction report. So we're talking about federal or state healthcare related criminal convictions. Donna spoke about these briefly earlier in the context of OIG exclusions. Criminal convictions related to the delivery of healthcare items or services are required to be reported to the National Practitioner Databank. Healthcare related civil judgments are also required to be reported to the National Practitioner Databank. And then finally, if a federal agency or state law enforcement agency or state Medicare fraud unit or a state agency supervising a state healthcare program takes a final action against a provider, and that provider is given some sort of due process mechanism, which that's an important element of this, they're given some sort of due process, which just means they get an opportunity to go to a hearing or a trial to say that's not what happened and present some sort of evidence. That's what we're talking about when we say due process here. And if it affects the payment, provision, or delivery of a healthcare item or service, if a final action is taken by a state or federal agency, you're given due process, has to do with healthcare, that's reported to the National Practitioner Databank under the judgment or conviction report. And then finally, our big catch-all one here is the adverse action report. The type of things that are reported on the adverse action report, and again, this is the 1,000-foot view. Adverse clinical privilege actions, if a professional society takes an adverse action against one of its members, state licensure action, right? A state board of medical examiners or a state board of nursing, federal licensure or certification action, peer review organization, private accreditation organization that has negative actions or findings, and then if you're excluded from participation in federal or state healthcare programs. All of those actions would fall under the bucket of the adverse action report to the National Practitioner Databank. So what are the consequences for not reporting to the National Practitioner Databank? So on this first slide, we're going to talk about the consequences for those entities that have an obligation to report that are in the private sector, right? So if a healthcare plan fails to report, they'll be subject to a civil monetary penalty for each adverse action not reported. That could be substantial. If a hospital or other healthcare entity fails to submit adverse clinical privilege reports, it can lose for 3 years immunity protections for professional review actions. That's a pretty substantial consequence to lose immunity for 3 years. And finally, a malpractice payer that fails to report would also be subject to a civil monetary penalty. So those could be pretty substantial. Now, by contrast, if you are a state or federal agency and you fail to report to the National Practitioner Databank, the name of your agency will be published publicly. That is the consequence. So as you can see, the consequences are a lot more serious for actors in the private space as opposed to the public space. I think the rationale behind that, of course, is that if you're a state or federal agency, you probably don't really have any incentive for not reporting to the National Practitioner Databank, while a private entity may have some concerns, right? They have a relationship with a provider. Maybe it's a doctor who's been on staff for years and years. They don't want to destroy their career. But if they take an action that's required to be reported to the National Practitioner Databank, it needs to be reported. And just to wrap up here with the National Practitioner Databank, Donna and I were talking about this as we were getting ready for today. And she asked me to keep some information in here related to impaired practitioners because she said this is something that she saw quite often on the compliance side of things. So hopefully this applies to some of you in the compliance space as well. So in October 2018, the National Practitioner Databank updated their guidebook, and they updated their guidance in terms of what needed to be reported to the National Practitioner Databank, and it did so in particular as it relates to impaired practitioners. So the new guidance is that A board, and when we say board here, we're talking about a board of medical examiners or a board of nursing or board of physician assistants, whatever the regulatory board is, should file an adverse action report under the following circumstances. And I'll just kind of summarize what we have here, and you should have the slides after today, so you'll be able to look back at this as well. But if the board issues an order for an agreement not to practice, that's an adverse action report. If the board takes an adverse licensure action and the provider enters into treatment, the adverse action still needs to be reported. If the board allows a practitioner to put their license into an inactive status or agree not to practice while under investigation or in exchange for not conducting an investigation, that should be reported. By contrast, the board should not file an adverse action report under the following circumstances. So these are circumstances where a practitioner has entered into a substance abuse treatment program and the board knows about it, but they haven't disciplined the provider. That doesn't require any reporting to the National Practitioner Databank. If a practitioner just voluntarily surrenders their license and they're not under investigation, that doesn't need to be reported. If they enter into a treatment or rehabilitation program and their agreement with the rehabilitation program is not to practice, that doesn't need to be reported because they haven't been ordered to do so by their regulatory board. That's the difference here. And if the board sort of suggests that a practitioner enter into treatment, but it's not board ordered for them to do so, and they're not disciplined by the board, that doesn't need to be reported to the National Practitioner Databank. So they're really trying to give some clarity to reporting entities here. We're dealing with impaired providers and knowing that this is a very sensitive topic to ensure that things are appropriately reported and that other states and other hospitals have notice when notice is appropriate. But if a provider is just seeking treatment on their own, maybe through your state physician health program, that something like that is not reported if someone's just doing the right thing and getting help when they need to. And then just some final thoughts. If you're an entity or a part of an entity with reporting obligations, be aware of what those obligations are. Right? There's a lot of really good guidance in the National Practitioner Databank Guidebook, which we have a link to here. If you're a provider, you're working with a provider and a report's been submitted that's not appropriate, that can be contested. Right? A report can be taken off or voided if it wasn't appropriately submitted. And then be mindful again, just if this applies to you, that there are some new reporting updates as of fall 2018. And Donna, I will turn it back over to you for our key takeaways.
Thanks, Alex, and thanks for keeping the impaired practitioners in there, because I do feel that that's been an area for me in the past where it's always a difficult investigation, a difficult conversation, and lots of big decisions for licensed practitioners to consider. So I appreciate the extra conversation about that. Thanks so much. So so let's wrap it up with some key takeaways from our session today. So first, certainly going back to the very beginning, right? Just some really strong pre-hire practices, making sure that everybody understands what our expectations are and that we have a way to monitor to make sure that we're following and really making sure that the right people are taking care of our patients and joining our organizations each and every day. Evaluating your monitoring process, right? How are we going to manage all of these practitioners, as we said, in that mobile workforce world that we have today? What controls and what processes are we going to put in place? What communication expectations do we have to make sure that our licensed and credentialed professionals or practitioners are continuing to be in good standing? And then third, as you are addressing some of these potential reporting scenarios, I put in, quote, call a friend. My general counsel and some of in the world of compliance, I use them almost every day, trying to make sure we were making good, sound decisions. And I would always encourage you to utilize those resources as you're making these difficult decisions. Sometimes outside counsel has just certainly a better understanding of the legal world, but at times too an unbiased perspective that is very, very helpful. And then, as Alex helped us at the end of this session, really understanding what the NPDB reporting requirements are, and even at the end mentioning the ability to contest certain things that are in that list if you have a practitioner that has some concerns, understanding those rights as well. So with that, on behalf of Alex, thank you so much for joining us again. And Alex, a special thank you to you for joining us, and we look forward to having you again on a future webinar. So Matt, I will turn it over to you and wrap it up.
Sure. Thanks, Donna. And we have enough time for one question, and I think this one is best for you, Donna. Susan asks, would it be appropriate to request a NPDB report for all physicians requesting to practice at an SNF?
Actually, I would let Alex answer that if she doesn't mind.
Yeah, happy to, Donna. Susan, thank you for the question. If your entity has permission to query on the National Practitioner Databank, which is the first big if, and I'm just saying that for everyone on the call here, because as I mentioned earlier, I represent providers who have National Practitioner Databank reports, and I'm not allowed to access them, so it's just a select group of entities out there that can. But if you do have access as an organization to the National Practitioner Databank, I would say use that information. That's what it's there for. So as Donna's talked about, setting up these good pre-hire practice and these good ongoing monitoring practices, and that's a lot of what Provider Trust does, that if you are able to access the information from your entity, if you're a qualified entity to query, use that. If you go to the National Practitioner Databank guidebook, you can see, depending on what entity you're a part of, whether or not you have any ability to query, whether that ability is permissive, or whether you have any mandatory obligations to query at different points of whether you're hiring someone or some other action is being taken. So Susan, I hope that answers your question. If it doesn't, or if you have further questions, please feel free to reach out to myself or to Donna. We're happy to follow up with you.
Great, thank you,
Thanks,
Alex. Oh, sorry, go ahead, Donna.
I was just going to say, we can follow up afterwards. We kind of have a NPDB FAQ of kind of who can query the database, and I think that would help Susan. So we can follow up with her after and share that as well.
Great. And on that topic, as we close here, I just want to remind everybody that you will be receiving a recording of the presentation, a copy of the slides, and your CEU certificate over the next couple hours. So be on the lookout for that. As well, this slideshow will be clickable, so all the links you've seen, you'll be able to access directly through this. Some of those being our resources that we're happy to share with you guys. And we'll also share Alex's contact information for anybody that may want to follow up with her. So with that, and on behalf of us at Provider Trust, I want to say thank you so much for spending your hour with us today. We really enjoy having you here, and please fill out the survey after this presentation, so we can continue to deliver value to you guys and make sure we're talking about stuff that you guys want to learn about. So please just join us next month, and so it's great to share this time with you. Thank you, and have a great rest of the week.